Well, good morning, all those that are here. I'm Alan Spargo. I'm the clerk for Hemmant's List, and this is a Hemmant's List presentation. The audience today consists of the people in the room, of which there are quite a number. There are also a considerable number who are taking this presentation by web stream, and yet again there are still others, some law firms, that are going to be taking on board the recording of the session for their CPD programs, and we'd like to welcome one and all of you. Just by very small way of introduction, I'm the clerk for Hemmant's List, which is a diverse list of barristers, some 40-something barristers at the moment, but more importantly, a considerable number of those barristers practice in the areas of family law and estate succession law, which of course are very much providing a situation where people have a particular interest in the topic that's under consideration today. Amongst our audience are obviously family lawyers and succession lawyers. There are also representatives of accounting firms that have private wealth management operations and have provided or will provide going forward advice to their clients concerning these pre- and post-nuptial agreements that we're going to be talking about today. And we also have, I believe, representatives of underwriters, insurance underwriters, that have potentially significant exposures in the areas where their insureds, be they lawyers or accountants, etc., have in the past or will in the future provide advice concerning these sorts of agreements, and perhaps with lawyers, the drafting of these particular documents, if you ever decide to draft them again after you hear what Keith Wilson's got to say. I think the topic has aroused considerable interest. I know just from going around talking to people after we put this invitation out that there seems to be a real concern about past exposures and a confusion as to where to go in the future. So we've asked Keith Wilson, QC, one of our list members, to come along and try and clarify the decision for you, to take you through the facts, what the court had to say, what the implications of that are, and probably just as importantly, where to from now. So without further ado, I'm going to hand over to Keith, who's probably, I hope, going to allay some of your fears and bring an element of happiness into the picture. But you never know with Keith. So over to you, Keith.
I've never been one accused of bringing happiness into people's lives, but see how we go. Hopefully the convergence of technology will work. If it doesn't, we'll do the best we can. I'm assuming that everyone has either heard of or read about Thorne and Kennedy. I'll take you through the facts shortly, but if ever there was a case destined to result as it did, Thorne and Kennedy was it. Before I turn to the case, in December 2000, the Commonwealth Parliament introduced amendments to the Family Law Act that permitted initially married couples and subsequently de facto couples of both sexes to make their own agreements as to how their property and maintenance obligations would be dealt with at the end of their relationship. In this day and age, that hardly seems remarkable, but it is very much a modern development. Such an agreement, as provided for by the Act in Parts 8A and 8B, is no more than a contract. Contracts are not inviolate, and there are well-established principles as to the circumstances in which one contracting party will not be held to his or her bargain. First, some brief history to see how far we have come in a relatively short period of time. The law of marriage was both part of the common law, in the sense that it was a contract and a status, but also part of ecclesiastical or canon law, in the sense that it was a sacrament. Prior to 1858, that is only 160 years ago, in England, matrimonial matters were dealt with by the consistory courts of each diocese, usually presided over by a bishop or the bishop's chancellor. And that had continued to be the case since an ordinance of William the Conqueror in 1072. When Australia was settled, there was for some time doubt as to whether the courts of the colonies in fact had any ecclesiastical jurisdiction, and there was a view that disputes in such matters had to be taken to England. Because a marriage was regarded as indissoluble in the eyes of the church and of society, the courts were concerned principally with two topics. First, the validity of marriage, and secondly, the legitimacy of children, which of course was important for succession rights. It was only if a marriage was declared void that either of the parties were free to marry another person. The only exception to that was if a party could convince the Parliament to pass an act endorsing their divorce or permitting a remarriage, but that was a remedy open to a select few. The English ecclesiastical courts granted four principal forms of matrimonial relief: decrees of nullity of marriage, divorce a menso et thoro, restitution of conjugal rights, and jacetation of marriage. Note, no relief in the form of property rights was exercised. A divorce a menso et thoro was a form of judicial separation granted on two grounds only: adultery by the other party and marital cruelty. Such a decree did not dissolve the marriage, but permitted the parties to live apart, and again, it said nothing about their property. Two of the other four decrees are self-evident. For those interested, jacetation means boasting, and it was a form of injunction to stop a person boasting that they were in fact married to a person when they weren't. Divorce on very limited grounds was permitted by the Matrimonial Causes Act in England in 1857. And in Australia, of course, at that time, the courts were those of the states. And the statutes, both in England and in Australia, permitted the courts to make financial adjustments between the parties. The Commonwealth of Australia did not become substantively involved until the Matrimonial Causes Act of 1959. As to maintenance, at common law, a husband was under an obligation to provide his wife with accommodation, food, clothing and other necessities of life appropriate to his estate and condition in society. That duty was suspended if the wife committed adultery or deserted the husband. Lord Justice Denning explained it thus in 1952. And I've put that slide up because it seems that by some financial agreements, including that in Thorne and Kennedy, that is not unlike what some husbands seek to achieve. It cannot be a surprise that modern courts will not countenance such an approach. As well as the Matrimonial Causes Act, the other significant piece of legislation was the Married Women's Property Act, which permitted women to own their own property. Until that time, the doctrine of unity had the effect that all property, including property brought into the marriage by the wife, was owned by the husband, and a wife had no property of her own. Once the Married Women's Property Act commenced, the starting point for consideration of matrimonial property became the ordinary rules of law and equity relating to real and personal property. That is, one starts by looking at the legal and equitable title to the property. The unjustness towards people such as homemakers in long marriages is obvious. In 1929, the House of Lords held that an agreement between the parties could not exclude the power of the courts to make financial adjustments between parties following the breakdown of a marriage. And that was a case of Hemmant and Hemmant in 1929. If we skip forward then, Section 87 1K of the Matrimonial Causes Act 1959 empowered the court to sanction prenuptial or postnuptial agreements concerning property distribution or maintenance, and the power of the courts to do so was upheld by the High Court in Shaw and Shaw in 1963. Property adjustment remained a matter for the courts until the amendments in 2000. Section 79 of the Family Law Act, with which most of you are probably familiar, entitles the court in the exercise of a discretion guided by a number of factors to permit orders to be made affecting the property interests of parties to a relationship once that relationship has ceased, and there are cognate provisions for de facto arrangements, provided certain geographical and temporal tests are met. By the 2000 amendments, the legislature recognised that in modern times parties should be permitted to negotiate their own arrangements for the division of their property at the end of their relationship. There are two types of agreements, colloquially called prenuptial and postnuptial agreements. Section 90B deals with agreements before marriage. Section 90C deals with agreements during marriage. You can see what a financial agreement is, and Section 90B2 deals with what the agreement can deal with. And Sections 90B3 and 4 deal with termination, and 3A is a very wide provision as to the matters that the agreement can deal with. Section 90D deals with agreements made following divorce and is in not dissimilar terms. The legislation imposes formal requirements, such as a separation declaration, for the agreement to be in writing and signed, and relevantly to what happened in Thorne and Kennedy, for a certificate of legal advice to be provided to each party. And under Section 90G of the Act, advice has to be given to both parties about the effect of the agreement on the rights of the party and about the advantages and disadvantages to that party of making the agreement. Can I just pause there and say one thing that's made clear by Thorne and Kennedy and the publicity that's followed it is that the giving of that advice and the provision of that certificate should not be a tick and flick exercise, but is something that needs to be approached with some care. I've put up Section 90F, and in particular Subsection 1A. This is a provision that the High Court wrote to the parties about and invited submissions as to how it applied to that case. The parties didn't take up the High Court's invitation, and so the High Court said nothing in its judgment about Section 90F1A, but you'll notice that it only applies to maintenance and not to the division of property. That is, if the financial agreement is effectively to leave one party destitute such that they'll go on to government benefits, there remains the power of the court to intervene, at least so far as maintenance is concerned. Section 90G is in effect the converse of what happened in Thorne and Kennedy. As I said, there are various formal requirements for a valid financial agreement, but there remains a discretion in the court under subsection 1AC to impose the terms of the financial agreement, notwithstanding some deficiency in the formal execution or otherwise of the document, if it would be unjust, inequitable not to do so. And you'll notice the language there of justice and equity mirrors that in section 79(2) of the Act. Then we come to those provisions that were expressly considered by the court in Thorne and Kennedy, and you'll notice that there are obvious provisions that apply to entitle a court to set aside agreement. For example, fraud, agreements to defraud creditors or defeat creditors, and that arose from some notorious cases involving Mr. Archer and Mr. Rich, where agreements were made during the marriage to transfer assets to the wife so that they did not form part of the husband who was facing imminent bankruptcy's estate. Importantly, subsection B of 90K, the court has not commented on what unenforceable adds to void or voidable. Can I suggest that it may refer to things such as estoppel or the device of a constructive trust that was utilised in de facto cases before the provisions were put into the Family Law Act in cases such as Baumgartner. In those cases, the financial agreement may be quite valid, but it may be unenforceable for those reasons. And then the subsection that was made reference to in detail in the case of Thorne and Kennedy, subsection E. Now, the legislature has seen fit to add, there's subsection B again. One would have thought that if it was entered into as a result of unconscionable behaviour, it would be voidable, but the legislature's seen fit to make it expressly or make it clear that unconscionable behaviour is one of the bases for setting aside an agreement. And section 90KA makes it clear that the principles of law and equity that are applicable to determining the validity, enforceability and effect of contracts applies. Going back to what I said earlier, in the case of marriage, it's a contract. It's treated no differently to a commercial contract in terms of the principles to be applied, and that was the way that Thorne and Kennedy was argued. So, whilst parties are free to make an agreement, it is susceptible, like any other contract, to being set aside if certain vitiating conduct is present, and there's nothing startling about that. This is what was said in the explanatory memorandum when the 2000 amendments were brought in. The legislature thought that the agreements would only be set aside in limited circumstances. But as will be seen, if one simply applies the principles applicable to contracts, the factual circumstances in which agreements can be set aside are very wide indeed. And it's to be remembered, and courts are jealous of their jurisdiction, that if there is a valid financial agreement, section 71 capital A of the Family Law Act provides that the jurisdiction of the court is ousted. Which brings us to Thorne and Kennedy itself. And as I said, if ever there was a set of facts upon which to seek to set aside a grossly unfair financial agreement, this was it. Most of you are probably familiar with at least some of the facts. Mr. Kennedy was a 67-year-old Greek-Australian property developer. He lived at the Gold Coast. He was divorced and had 3 adult children. He was worth between $18 and $24 million. Ms. Thorne was a 36-year-old Romanian lady who had also divorced. She had no assets of substance. Both parties spoke Greek. Ms. Thorne spoke and understood English, but it was not her first language. At the trial, over objection, she was permitted to give evidence through an interpreter. However, it was found that she was able to and did understand the documents presented to and explained to her. The parties met, if that is the correct term, on the internet in mid-2006. The wife's profile was as follows: I am single female with no children. I don't smoke or drink. I am of Greek Orthodox religion and speak a little Greek and English. I wish to marry and have a good life. That obviously attracted Mr. Kennedy because he contacted Ms. Thorne. The parties spoke on the telephone and Mr. Kennedy travelled to Europe in July 2006 to woo Ms. Thorne. It was accepted that early in their courtship, Mr. Kennedy, who was obviously a very romantic man, said, I will come to your country and we will see if we like each other. If I like you, I will marry you, but you will have to sign paper. My money is for my children. And Ms. Thorne was aware, virtually from the outset of the relationship, that Mr. Kennedy wished to put in place arrangements to leave at least the vast bulk of his estate to his children. The parties obviously got on well because in February 2007, Ms. Thorne moved to Australia and moved to live in Mr. Kennedy's penthouse apartment. Now, sometimes you get a fair idea of where a judge thinks the merits lie in a dispute in some of the detail in the reasons for judgment. Here, under the financial agreement which we'll come to, Ms. Thorne was to receive $50,000 if the parties remained married for more than 3 years. Although there was no particular need to do so, the judge described where the parties lived in Mr. Kennedy's apartment. You know it's not going to go well for Mr. Kennedy. The parties set their wedding date for the 30th of September 2007. Invitations were printed and dispatched. The dress was designed and made, and the reception venue was booked. On the 8th of August, the parties attended on Mr. Kennedy's solicitor for the purpose of Mr. Kennedy instructing his solicitor to prepare a financial agreement to be signed prior to the wedding. Although she went to the meeting and exchanged pleasantries with the solicitor, the meeting between the solicitor and Mr. Kennedy was in private. They had another conference for the purpose of refining the terms of the agreement approximately a week later, on the 14th of August. The draft agreement prepared by Mr. Kennedy's solicitor included, importantly, a provision that an agreement would also be signed after the wedding. So there was to be a Section 90B agreement signed before the wedding and then a Section 90C agreement signed following the wedding. The second agreement was to be the same as the first. The solicitor included the provision in the first agreement as he was concerned about the proximity of the wedding date and that it may be considered that the agreement was signed in haste, which might be considered to amount to stress and pressure. And the solicitor had a number of conversations with his client about the agreement not being signed on the eve of the wedding. First set of warning bells should go off. As the wedding drew nearer, preparations continued to be undertaken. The bride's parents and sister were flown to Australia by the groom. They were accommodated and matters proceeded. Then bearing in mind the wedding's on the 30th of September, on either the 16th or the 19th of September, probably the latter date, Mr Kennedy told Ms Thorne that they were going to see some solicitors about the signing of some documents. As I said earlier, Ms Thorne knew that Mr Kennedy was desirous of having a document prepared. An appointment was made to see an independent solicitor. Ms Thorne asked Mr Kennedy whether she would have to sign the agreement. He told her if she did not sign, the wedding would be off. Before going to see the solicitor, it was found Ms Thorne knew she had two alternatives: sign the document, or the wedding and the relationship would be over. Ms Thorne saw the solicitor on the 20th of September in the presence of her solicitor. Mr Kennedy waited in the car outside. More warning bells. The solicitor advised Ms Thorne not to sign the agreement. You might have seen this in the press. The solicitor said, "It is the worst contract I have ever seen. Don't sign it." Very loud warning bells. The solicitor sent a letter of advice confirming what was said in the conference. And this is part of the letter of advice. And as lawyers, we should be aware that when things go wrong, sometimes our letters of advice do end up becoming public and before a court. This solicitor acted entirely appropriately. Ms Thorne went back to the solicitor on the 24th of September, now less than a week before the wedding, and the solicitor went through the letter of advice with her. It only appears in the High Court judgment, in one of the judgments, but it appears that the solicitor was so concerned that she went to see a partner at the firm as to how she should handle the circumstance where the client was willing to sign the agreement in circumstances which the solicitor considered were perhaps those of duress. And the partner, as sometimes they do, helpfully said, "She can sign or not sign, toughen up." So the solicitor maintained her advice that the agreement should not be signed, but it was. The agreement was signed on the 26th of September, 4 days before the wedding. Both solicitors gave the certificate required by the Act. The agreement provided for a number of eventualities, including what would happen in the event of the death of Mr Kennedy, and a significantly more generous provision was made in that regard than what would happen if the parties separated. But relevantly for the purposes of the case, we're concerned with their separation. If they remained married for less than 3 years, Ms Thorne got nothing, not a cent. If they remained married for more than 3 years, she received $50,000. This is a man whose estate is worth 18 to 24 million. And that $50,000 figure didn't change depending on how long they remained married. And it was described in the judgments as a piteously small sum. As I said earlier, the first agreement contemplated a second after marriage, and Ms Thorne went to see her solicitor again on the 5th of November. The solicitor again told her it was a terrible agreement and she shouldn't sign it. The solicitor recalled that during that second meeting, the husband was again outside in the car, and he in fact called the wife and asked her how much longer she was going to be. The solicitor gained the distinct impression that the wife was being pressed not to spend too long, but simply to have the document signed, which it was. The marriage lasted until the 16th of June 2011. More than 3 but less than 4 years. The wife brought proceedings to set aside the 2 financial agreements. On a side note, how she came to bring proceedings is illuminating. Apparently, Ms Thorne was complaining to her hairdresser, which I understand is the modern equivalent to the confessional, that her husband was leaving her with a meagre sum. A voice from an adjoining chair said, "I know where you can get a lawyer." And the rest, as they say, is history. Mr Kennedy was still alive when the proceedings commenced. In fact, the trial commenced. Mr Kennedy died after his cross-examination commenced, but before it was concluded. I should say he did not literally die during his cross-examination. The case was adjourned off because of a valuation issue, but the executors were substituted so that the matter could proceed. The decision at first instance of Judge Demack is reported at 2015 Federal Circuit Court of Australia 484. In my respectful opinion, Judge Demack made only one error in her reasons, and that was forgiven by the High Court Justices. Her Honour decided that the agreements were voidable because of, quote, duress, close quote. However, in her defence, at paragraph 68 of the reasons, Her Honour said that, quote, duress is a form of unconscionable conduct. Her Honour, if one reads the reasons, plainly did not mean duress at common law, which involves an unlawful threat. And that was acknowledged by the justices in the High Court. However, the use of the word duress then took on a life of its own. There was no issue about Ms Thorne's capacity to understand what the agreement provided for. She understood the advice that was given to her by the solicitor. This is a bad agreement, don't sign it. The basis of Her Honour's decision is at paragraphs 89 to 93 of the reasons. First, the husband was not prepared to negotiate. It was a take it or leave it situation. If the agreement proffered was not signed, the wedding and the relationship were off. Secondly, Ms Thorne loved Mr Kennedy, wanted to marry him and have a child. She had changed her life and moved to Australia to be with him. That's what Her Honour said at 91. That's Mr Kennedy's position. And you'll see in Her Honour's language that she's plainly referring to undue influence and unconscionable conduct as opposed to common law duress. But then Her Honour says at 94 that the wife signed the agreement under duress. But then the second sentence makes it clear what Her Honour was really saying. Now, the use by Her Honour of the word duress, as I said, sent the hounds running. And the full court, which seems to have been overly keen to set aside the decision, found that there was no basis on which to make a finding of duress and set aside the judgment. The reasons of the full court are at 2016 Family Court of Australia, Full Court 189. There were 13 grounds of appeal. There were 8 grounds in a notice of contention. But the appeal was allowed for 2 very simple reasons. The first was the full court found that in that paragraph, Her Honour didn't place weight on any particular factor, and therefore her reasons were inadequate to establish duress. It was said that a finding of financial inequality would never provide a reasoned basis for duress. That is correct, but in my respectful view, a superficial approach to the way that Her Honour dealt with the problem. And as Chief Justice Kiefel said during the argument of the appeal, as to paragraph 93 of the trial judge's reasons, and said this about the full court, their honours do not seem to realise that this is a finding of fact. They seem to think it falls with an incorrect assessment of what amounts to duress. Interpose, ouch. It was said that although Ms Thorne had pleaded a claim for relief based on undue influence and unconscionable conduct, because she used the word duress, Judge Demack only accepted the claim on that basis, and it found that the judge had applied the incorrect test for duress. A notice of contention raised undue influence and unconscionable conduct, but that was dismissed because it was held that there were insufficient findings of fact to support such conclusion. It was said that because the wife had no concerns as to what she was receiving under the agreement, there could not be undue influence. It was held that the wife's consent to the agreement was a true consent, and that was notwithstanding the concession based on then existing authority that the relationship of fiance and fiancée raised a presumption of undue influence. The court in fact said, we emphasise that the wife could not have been influenced at all by the husband when she had no concern about what she would receive upon separation. When one has a look at the facts of the case, one shakes one's head at that comment. Further, whilst the full court accepted that the wife was in a position of disadvantage vis-à-vis the husband, it concluded that the evidence did not support a finding that the conduct of the husband was such that he took unconscionable advantage of the wife to secure her signature to the agreement. In this regard, the full court considered that the real difficulty for Ms Thorne was that she was provided with independent legal advice about the agreements. She was advised not to sign them, but she went ahead regardless. That is almost the exact opposite of the view taken by the High Court as to the role of the legal advice given to Ms Thorne, and is expressed in language that ordinarily is used when dealing with issues of causation. That is, it didn't matter what legal advice you were given, you were always going to sign this agreement. If one reads the transcript of the special leave hearing on the 10th of March 2017 before Justices Keane and Edelman, there is little doubt about what's going to happen to the decision of the full court. Their honours were keen, no pun intended, to examine how equitable principles applied in the marriage and intimate relationships arena. In particular, they were interested whether the Amadio doctrine of special disadvantage had a broader application in such circumstances, which they acknowledged gave rise to large policy questions. They were also interested in whether there was, in Australia, to be accepted a concept of lawful act duress, or, as is sometimes known, economic duress. But the way in which the appeal was argued did not address any of those matters. It was accepted by the appellant that the same principles applied in the context of Parts 8A and 8AB of the Act as applied to commercial contracts. The court, perhaps anticipating more subtle arguments, sat a bench of 7. The appeal was argued on the 8th of August and judgment was delivered precisely 3 months later. If after the special leave application the appellant had any misgivings as to her prospects of success, they were swept asunder during oral argument. Counsel for the appellant sought to maintain the finding of duress. The court, on a number of occasions, interrupted him and asked why he needed to go so far when there was unconscionable conduct demonstrated on the evidence. In response to a submission that the appellant could not succeed because she had received independent legal advice, the Chief Justice said, "Independent legal advice can never overcome a case of undue influence, duress, and perhaps not even unconscionability." In fact, it was said that the giving of legal advice made the appellant's case stronger. The fact that, despite being given strong legal advice not to sign, a party in fact signs can be a strong indicator that there is duress or undue influence. And Their Honours said particularly where there is no offer to negotiate. 3 judgments were delivered. All 7 justices allowed the appeal. The plurality on the basis of undue influence and unconscionable conduct. Justice Nettle would also have allowed the appeal on the basis of lawful conduct duress, but also undue influence and unconscionable conduct. And Justice Gordon allowed the appeal on the basis of unconscionable conduct, but not undue influence. I commend the entire judgment for not only its clarity, but also for its direct language. There is, I submit, no doubt about what the court was thinking of the financial agreements in this case or the conduct of Mr. Kennedy. The best example in that regard comes from Justice Nettle, at all times a plain speaker, which I will come to shortly. As I said, the plurality were kind to Judge Demack. They considered that she used the label duress interchangeably with undue influence, which Their Honours said was a better characterisation of her findings. The plurality found that the agreements were voidable and observed at paragraph 23 of the reasons that no distinction was sought to be drawn between the principles of unconscionable conduct in equity and those within section 90 KA 1E of the Act. To that end, the court applied well understood principles to a contract between persons who happened once to be married, which was a factual circumstance relevant to the inquiry. Their Honours considered that causation was not an issue. They did so because where conduct is shown to be either unconscionable or as a result of undue influence, there is an unavoidable inference of causation if the particular transaction could not reasonably be accounted for by ordinary motives. Their Honours left open expressly for another day what would happen if the duress, undue influence or unconscionable conduct were that of a third party. For example, a parent or relative of one of the betrothed, one of the adult children of a blended family. Their Honours said that such a case would raise additional issues. So that point is left for determination on another day. At 29, the plurality considered that it was not necessary for the primary judge to consider common law duress, and Their Honours explained that the sense in which the judge used that term was to focus on the lack of free choice in the sense used in undue influence cases, rather than whether Mr. Kennedy was the source of all the relevant pressure, or whether the impropriety or illegitimacy of Mr Kennedy's lawful actions might suffice to constitute duress. Their Honours acknowledge that the boundaries between undue influence and duress are blurred, but their Honours said that although they did not decide the case on the basis of duress, that it is unnecessary for a conclusion of undue influence for the pressure to be characterised as illegitimate or improper. That's what the plurality said about undue influence, and that is, in my view, no different to what has been said since Amatio. The one matter that their Honours did, if you like, change the law about was this, that at Reason 35, their Honours held that in the case of fiance and fiancée, or in any relationship of intimacy, there is now no longer any presumption of undue influence. Their Honours were at pains to point out that such a conclusion ought not be confused with the principles stated in cases such as Yerke and Jones and Garcia in the National Australia Bank about the married women's equity in financial transactions that arises because of her reliance upon and dependence upon her husband. As to unconscionable conduct, the court applied the principles restated in Kakavas and Crown Melbourne and said this at paragraph 38. Their Honours explained the different spheres of operation of undue influence and unconscionable conduct, and again referred back to what Justice Mason had said in Commercial Bank and Amatio. What their Honours helpfully did or highlighted was the important role that is played by a trial judge in these sort of cases in assessing the interplay between the parties, the terms of their relationship, an estimation of their personality and capacity, and such matters are extremely important when deciding whether to apply concepts such as undue influence and unconscionability, which involve how the mind of one person is affected by the actions of another. Their Honours pointed out that none of the findings of fact made by the trial judge were overturned by the full court, and with one exception. The full court had rejected the finding that there was no outcome available to Ms Thorne that was fair or reasonable. The full court was said to have erred in rejecting that finding. Their Honours said the description of the agreements by the primary judge as not being fair or reasonable was not merely open to her, it was an understatement. Another ouch for the full court. Then, in my view, the next two passages are the important ones to take out of Thorne and Kennedy. That is, it is relevant to look at the fairness of the agreement, whilst recognising that these agreements are usually used in cases where there is a great disparity of wealth between the parties. And in considering those matters, at paragraph 60, their Honours set out 6 factors that should be considered in these sort of cases. And if one takes those 6 factors and applies them when you're advising either the rich party or the poor party, that will give you a guide as to how to approach the matter. One shouldn't do what Mr Kennedy did, and insist that the agreement be signed 4 days before the wedding. Wait outside in the car, say that there was no negotiation, etc., etc. As I said, Justice Nettle would have allowed the appeal also on the basis of lawful act duress, but also decided that the appellant succeeded on the basis of undue influence and unconscionable conduct. Lest there be any doubt what Justice Nettle thought about the matter, have a read of paragraph 75. I'm not sure that you can be much blunter than that. The judgment of Justice Gordon is perhaps the blackest of black-letter law judgments. It also demonstrates that minds might differ as to the correct characterisation of conduct as being unconscionable or as exerting undue influence or as amounting to duress. Her Honour considered that Ms Thorne's will was not overborne because she made an informed and voluntary decision to proceed to sign the agreements and therefore was not subject to undue influence. However, at 81, paragraph 81, Her Honour said that although her independent, informed and voluntary will was not impaired, she was unable to make a rational judgment to protect her own interests. Those circumstances were evident to and substantially created by Mr Kennedy, such that it was unconscionable for Mr Kennedy to procure or accept her assent to the agreements. The distinction may appear to be a fine one. On the facts of the case, it didn't make much difference. One, undue influence looks at the quality of the consent of the weaker party. The other, unconscionable conduct, looks at the conduct of the stronger party in unconscientiously seeking to take advantage of a special disability. Her Honour accepted that the two doctrines may be engaged by the same set of facts, but the focus of the inquiry is different. Her Honour made the point that undue influence does not protect against bad deals. Something more has to be involved. It must be something about being Victorian, but Her Honour also did not mince her words. And as to the receipt of legal advice by Ms Thorne, Her Honour said what is on the slide. That's the point that I made a little earlier. So both agreements were set aside. Can I say that on the facts of the case, that was hardly a surprise? In my view, Thorne and Kennedy is no more than the application of settled principles to quite extraordinary facts. However, it was the first time that the High Court had the opportunity to look at the terms of Part 8A of the Act and excited the interest of some commentators. That's two of the headlines. The first headline was written in a very long article in an online news publication, and the credibility of the commentator was cast into considerable doubt, in my mind at least, by the author's reference to the, quote, sage advice of Kanye West in his classic literary work, Gold Digger. where he exhorted the need for prenuptial arrangements because when the wife leaves, she's going to take half. What the decision means is that those tasked with drafting and advising upon financial agreements need to be aware of the principles of duress, undue influence and unconscionable conduct, and other factors which would vitiate a contract. That remark applies equally to those involved in estate matters, where a relative seeks to pressure an elderly parent to make a new will which favours them more than their siblings, or inter partes negotiations between members of rural families where one son claims that he should be left with a larger share of the family property than his brothers or sisters. The importance is for the solicitors to take detailed instructions, keep accurate diary notes, and probe the client as to the circumstances surrounding the proposed agreement. The solicitor who acted for Ms. Thorne came out of the case smelling like roses. She gave accurate, blunt advice, which wasn't followed, and kept the appropriate notes to support what she had said. It should never be doubted that it's by no means an easy thing to set aside a contract, particularly on the ground of undue influence or unconscionable conduct. It is a fact-intensive inquiry, and the more facts that are obtained contemporaneously with the transaction, the better a party will be in if the agreement comes under judicial scrutiny. Can I venture the view that a properly negotiated and drafted financial agreement is not threatened by decisions such as Thorne and Kennedy? What is under attack is the sort of agreement that should be invalidated. It was a crude attempt by a very rich man to disentitle his wife to any proper treatment. The principles to be applied to determine whether a financial agreement, as a contract, is voidable or unenforceable are no different to those that apply to other types of contract. As a paid professional, care is required in drafting an agreement, both from the point of view of the party with all the assets. They should be advised that if they want to act in a particular way, there's a very real chance that the agreement will be set aside. And if one is acting for the other party, to properly and fully advise them as to the consequences that may eventuate if they go ahead and sign the agreement. If acting for the wealthy party, encourage your client to be generous. Trying to enforce an agreement such as that in Thorne and Kennedy is going to be very difficult. That doesn't mean that the position of the wealthier party cannot be properly protected, but it should be done in a measured and reasonable way. If you have 18 to 24 million, why try and get away with $50,000? If Mr. Kennedy had instead provided for a more generous allowance, the conversation at the hairdresser's may never have taken place. Be open to negotiation. The High Court thought it was a critical factor that Mr. Kennedy presented as a take it or leave it proposition. Don't engage in brinkmanship or leave the agreement to the last minute. Have regard to those factors set out in section 60 of the reasons of the plurality. Ask questions. Give as fulsome advice as is possible. consider whether in the circumstances a financial agreement is in fact appropriate. Involve other advisors, such as accountants, investment advisors and family solicitors. Find out what structures are involved. I was at a seminar recently when a senior practitioner relayed a story of a case where family lawyers drafted a financial agreement, the effect of which was that on separation the parties would retain those assets in their respective names. The agreement was signed and put in a drawer and no more was said about it. Later, and not being told of the financial agreement, the husband received and acted on tax and accounting advice to put all of the assets in the wife's name. When the parties separated, you can appreciate that that led to considerable consternation. So involve as many of the parties' advisors as is possible, and, like a will, review the financial agreement regularly. Circumstances change. The agreement that is appropriate to parties who marry when the husband has very large wealth and the wife almost nothing might be appropriate at that time, but if they remain together for 10 years and the wife assists in the husband's business and helps to expand the wealth, is it fair and reasonable that the original terms continue to apply? Check to see if there are any internal inconsistencies in the agreement, in particular circumstances in which it is engaged. In short, approach the drafting of a financial agreement as one would a commercial agreement, and if the decision in Thorne and Kennedy achieves those practices, it will have more than served its purpose. Thank you.
Thank you very much, Keith. Keith has kindly offered to take some questions from the floor. We've got a roving microphone that will be taken around. If you could perhaps indicate if you've got a question by raising your hand, and it would be helpful if you indicated when you put your question your identity and the organisation you come from, if you choose to. So is there any questions?
Keith, Steve Benuto from Lexon Insurance. What relief was ordered by the judge, the trial judge, and also what relief was ordered in favour of the wife by the High Court?
The trial took place only on the validity of the financial agreements. By the time the High Court had finished with it, the financial agreements have gone, and it's now back before the court as an ordinary application for property settlement. Interesting to see what she ends up with.
Any further questions? Okay, all right. Well, could we now join in thanking Keith very much? Thank you very much, everybody, for your attendance, and we'll now let you get about your daily work. Thank you.